Welcome everyone. Welcome to the College of Law's third annual Admission to Practice Academy. This is the first of 9 events this week that will provide you with tips, insights and inspirations about admission to practice, give you some insights. So in this webinar, we compare and contrast the options of in-house versus private practice. Is it better to become an in-house lawyer or to work for a firm? Good question. The 2018 National Profile of Solicitors report found in the Australian legal profession of just over 76,000 legal practitioners, 69% were in private practice, 15% in corporate or in-house legal, 12% in government legal, and 4% other. And in the 7 years leading up to that report, there had been strong growth in the in-house and in the government legal sectors. In fact, both were up 61% over those 7 years, which is quite a large increase. So I'd like to introduce the panel members, Caitlin Surman and Tim Graham, and then we'll get underway. So Caitlin Surman is an associate at HWL Ebsworth, clearly the private lawyer, and Caitlin was admitted in July 2015. She's a member of the litigation team with a practice focusing on media, defamation law, intellectual property and technology, privacy law, and competition law. And Tim Graham. Tim is the General Counsel, Legal Operational Risk and Compliance with FlexiGroup. He was admitted in February 2027. Tim is an experienced corporate and commercial lawyer. He has a background in advising multinational clients on acquisitions, joint ventures and corporate restructures. He also specialises in corporate governance and consumer credit. Caitlin, I'll invite you just to introduce yourself and give a little bit of an overview of your journey to your role.
Sure. So I was admitted in July 2015 here in Adelaide. I commenced as a clerk at first with a firm known as DMAW here in Adelaide, and I worked there and then I was admitted as a solicitor after 6 months, and I proceeded to work there for about 2 years in their general litigation team, and then I moved over to HWL Ebsworth about 3 years ago to work with Peter Campbell, so first as a solicitor and then as an associate in July 2018. So I assist my partner, Peter Campbell, as Graham said, in the conduct of disputes in all Australian jurisdictions, and primarily in the practice areas of media and defamation, consumer law and intellectual property at the moment. And I also do a bit of advisory work in consumer law and privacy. So that's
fantastic.
Me.
Thanks, Caitlin. Tim, your turn.
So I was admitted in February 2007, and for about 3 years prior to that, I have been working as a law clerk in a very small law firm in Adelaide, doing a mix of commercial and court work. And then just soon after being admitted, I managed to get into Ellison, into the corporate team there in Adelaide, and stayed there for nearly 5 years, and moved together with a partner to what was then DLA Phillips Fox, which became DLA Piper. And ultimately I made the transition into in-house practice into a company called Adelaide Research and Innovation, which was the commercialisation arm of the University of Adelaide. And then just over 5 years ago, managed to find the role in FlexiGroup that I've had for the last 5 years.
Fantastic, thank you. Just a note for participants, we're going to go into a series of questions now, but if you've got any questions throughout the webinar, please post them via the Q&A chat function. We'll attempt to address them all. It will depend on how many questions are posted, of course, but we'll come back to those partway through the process. So Caitlin, what attracted you to your current role?
So I started as a clerk in general litigation and found that I really like that. But working in that first role wasn't necessarily in the practice area that I wanted to be in. So I actually did a media law degree. So I've always had an interest in journalism and the law. So when an opportunity came to work with Peter in the area of defamation in particular, I jumped at that and decided to move over. Again, my team is headed by some very experienced practitioners in that field. So I also considered that my role would be an excellent opportunity for my training and my development in an area that I really enjoyed. And it's also within a firm like HWL, there's a clear sort of manner in which you can move up the career ladder. So, which is a bit more clear than it was in my previous role. So those are sort of the main factors that drew me to my current position.
Fantastic. And what about for you, Tim?
For me, being probably that little bit more sort of senior along the way, what I was looking for was the opportunity to create a legal function. And this job has given me the ability to go from a sole in-house counsel to grow that team to 3 lawyers and then ultimately up to about 7 people in operational risk and compliance. And so it, I suppose, for me was the challenge presented by the amount and complexity of the work that needed to be done in generally fairly compressed timeframes. And
what are the things you like most about your role?
I suppose now it's the ability to lead the people that I work with. It's the opportunity to work extremely closely with the business and probably at the cutting edge of some areas of law. It provides me with the opportunity to sit with app developers as they develop the app so that we get things right, and just enables a sort of immersion in the business in a way that sort of contrasts to, I think, what's generally possible in private practice.
Good. And Caitlin, what about you? What are the things you like most about your role?
Probably the diversity and complexity of our matters, and also their size. So we're quite fortunate in our practice that we work for quite a few large media organisations, assisting in both their pre-publication work and in their disputes. So that's something that just personally interests me. So I enjoy that quite a lot. But I think just working in a private firm like HWL more generally, we are quite large. We do have a lot of practice groups, a lot of different teams. So when you work like that, there's a lot of opportunity as a young lawyer to get a little bit of exposure across a lot of different practice areas. So you often find that there's a bit of cross-pollination between teams. So if you're busy, if you're not very busy in a particular week, but say insurance is or insolvency is, there's always the opportunity for you to go across and do some work for those teams. So in that sense, you get a lot of exposure and a lot of experience in a lot of different things. And that's what I found sort of coming through so far. And also just the people that I'm around as well. So I've worked with some very experienced and well-regarded practitioners, and because of that experience, we do attract a lot of interesting matters. And I think it's an excellent opportunity working in a big firm with a name like this to get a chance at having a go at that work. So, absolutely.
Anything you dislike about your role?
My role?
Yeah.
So everyone probably knows, like, there's not a lot to dislike about it, but if you've ever worked or had experience in a private practice firm before, that's obviously the big elephant in the room, which is billing. So I'm not saying that I dislike it, but as a lawyer in a private practice, you do have, most firms impose billable targets on you. So you've got daily targets, annual targets. It's not the end of the world if you don't meet them, because obviously firms and your bosses understand that there are a lot of different factors that can affect whether or not those targets are being hit. So having said that, whilst it's not the end of the world if you don't do it, it does add quite a bit of pressure, particularly when you're young and you're starting out and you feel like you have to hit 100% every day. That's not the case, but it's just definitely that added pressure that might not exist in government or in-house. So
awesome. It's something that's sitting in the background always, yeah?
Yes, exactly. Yeah.
What about for you, Tim? What do you dislike about your role?
There's just a few things.
We've only got an hour, Tim.
I'll be quick. There's extreme pressure at times, but that does go with the sort of level of seniority of the role. There are at times high conflict situations to manage in the workplace. High conflict situations to manage with external stakeholders as well. And there have been in the past long periods of travel rolling through the different capital cities. And perhaps I'll just speak to the billables. While I don't have to bill time anymore, and there are still relatively few in-house teams that do track time, though some do in the same way as occurs in private practice. I still do have to manage an external spend budget, and I still do see the timesheets in from the lawyers we engage. And I do question the value in the longer term of the billable unit model for the profession.
Sure. And Caitlin, I'll just swing across to a question that someone has asked. What are the billable targets?
So it depends on your firm, but essentially it's, and it changes as well as you progress. So starting out as, and I'm only speaking for my firm, I don't know how other firms work, but starting out you have a set number of hours that you have to, of billable work per day that you need to achieve. So when I say billable work, I mean work that gets charged to the client, because in private practice there's also an aspect of your job which is non-billable work. So things like business development, so putting together presentations, just furthering your own personal development in your own time, basically. So, and you also, we have a specific charge out rate that your firm will bill you out at. So say, for example, I can't give you proper figures, but say my rate is $100 an hour. I have to hit 6 hours a day at $100 an hour. I have to bill $600 a day. So, and again, it's not like I'm checking it every day. I'm not being followed up about it every day. It's just a performance indicator that's eventually used as part of, for example, your career progression. So it might be that you have your performance review in the middle of the year and you want to ask for a pay rise. One of the factors that might be looked into is whether or not those targets have been met. So it's sort of, it doesn't affect my everyday, but it is sitting there.
It's sitting.
Yeah, perhaps I can give sort of more specific figures because I was a private practice lawyer once. And when I started out, I was expected to bill 6 hours a day, and then I was expected to recover 75% of that in terms of revenue to the firm. As I progressed along, that ultimately moved up to 7.5 hours a day billable at around, I think, $500 an hour in Adelaide. And I was expected to recover 95% of that as senior associate.
Okay.
And when you talk about recovery, for those that don't understand it, so you might bill something, but then it might be that you spent too much time on that one task and your boss can't justify charging the client for that. So it might be that they only bill the client for 75% of your work, and that actually gets reflected in your figures. Yeah. So that's just something, that's what he means by recoverable. Yeah.
And is
that right, Tim?
Because Tim can discuss this sort of thing because it's in the past, which is great. Yeah. Thank you. Thank you. Look, COVID aside, I'm curious to know, Tim, how much travel does your outside of COVID, how much travel is involved for your role?
Yeah, in my role, there were periods where I would be in Sydney or in Melbourne or in Brisbane for up to 2 weeks out of a month. There were times when I would be away from home 3 months out of a year, across a year. So I was looking at times weekly travel, at times back-to-back capital city travel as well. We're an organisation headquartered in Sydney with offices in Brisbane, offices in Melbourne, New Zealand as well. And so I think that's probably a relatively significant amount of travel for an in-house lawyer in Adelaide.
Sure, it is. It is, I would imagine. Yeah. Caitlin, what about you outside of COVID?
I personally don't travel outside of the state very often. Right. As I think what people will find, I travel to court and that's about it, but I think what most people will find as a junior, so we do work on here at HWL a lot of interstate matters, so we run them out of Sydney, we run a few out of Melbourne, but what as a junior or an associate level involves, you usually do a lot of that grunt work and you get ready for court, you get ready for trial, but unfortunately, and I think this is the case in most firms, the junior is not who goes over. So it'll usually be your partner or someone a bit more senior to go over and instruct. But again, the trade-off is you're a junior once, you'll eventually become a senior, and then you'll get to do it. So that's sort of how it works here. But I speak for my practice only. I know that other people in our firm do travel quite a bit, depending on where their clients are based. But personally, I don't.
Yeah, in private practice, I travelled, I suppose, less often than I do these days, pre-COVID. But prior to the GFC in particular, a lot of travel for transaction completions in Melbourne and Sydney, and that's sort of a defining memory from private practice for me, going interstate and working with all those lawyers on the bigger transactions.
Okay, I'm going to go on to a question, and we've got a few questions come up on the board. We will get to those in just a moment. Caitlin, does your role enable you to enjoy a suitable work-life balance?
It does, but there are, that's subject to qualification, obviously. So there's a lot of rumours out there, and this about, the work-life balance in private firms. I'm speaking from Adelaide, where things are a little bit different to the eastern states, and it also depends on the nature of your work as well. So here I'm encouraged to keep a work-life balance. I think my hours on an average day are about 8 till 6, so it's not too bad. I can maintain hobbies outside of work. I play netball. I've got a few other extra things that I do on the side there, and I don't feel pressure to not go to those things because of work. But having said that, your hours are ultimately dependent on the type of matters that you've got on at any one time and the time pressures that are associated with those matters. So obviously, if I've got an urgent deadline, if I've got a trial, and a piece of advice due the next day, I will stay until that's done. And it might be that I stay till midnight. It might be that I stay till 8. It just depends. But as a rule of thumb, there's no policy which says that I can't leave until 8 p.m. And I'm sure a lot of firms are like that. So again, it's just about managing your workload and what's required, and making sure that at any one point in time you're meeting your clients' expectations. That's really what guides how long.
Sure. Is it give and take a little if you do work till midnight? Can you?
Yeah, it is. Particularly, and it does come down to your team as well and how your team is run. I almost think of them as sort of little mini islands within a firm. So if I've worked, I did a couple of weeks ago, I did a really big chunk, 2-week non-stop chunk of 15-hour days, but that meant that my boss was happy for me once that was done to take a day off or to come in a bit later. So there is that flexibility, but again, it's subject to what the approach that your partner takes, essentially. And I'm very fortunate. I've got a very understanding partner.
Yes, yeah. And Tim, for you, work-life balance?
Yeah, in-house, I think probably does afford the opportunity generally for a fairly good work-life balance because, just like all the other employees, we're working for the company. We're not there sort of directly with the partners. But I have to say that has absolutely gone out the window in 2020 for me. And the year's been, I suppose, somewhat exceptional, but I've had, I think this year, more difficulties with work-life balance than I had even back in the early days of private practice. Though I did once stay at Midgerolson until the next day on a transaction. I don't know that occurs these days. I'm not sure that would be permitted. Sort of spending 36 hours in the office is not something I'd recommend. And, it was different back then, I think, being a lawyer. Recently, we had a Australian Competition Tribunal hearing process. We had to do a massive amount of preparation for that, and instructing one of the big 4 firms. I had to review with another lawyer about 10,000 pages of evidence. We did 29 days straight. We averaged about 12 to 15 hours a day, up to 18 hours a day. I'd say that's fairly exceptional in in-house practice, and not something that a junior practitioner should ever expect to walk into. But it does go with the more senior roles at times.
Okay, yeah. All right, well, thank you for that insight. So, Caitlin, your career progression, you mentioned this earlier.
Mhm.
I think you suggested it was relatively clear for what you're doing. What can you map it out?
Sure. So generally when you start in private practice, you come in as either a clerk or a graduate lawyer. And then generally speaking, you move up the ladder. So you start, then you go to solicitor. The next position is associate. The one after that is senior associate. Then we have a position called special counsel, which is one position below partner. So in terms, the reason I say clear is that, and again, I speak for my firm only, when you start, there is a clear criterion for each position. So you know the particular things that you need to do in order to progress to that next stage, in terms of the level of autonomy that you exercise, the level of responsibility more generally, whether or not you're delegating, the level of complexity of the matters that you're working on. So when we start, we're given a guide. The guide tells us exactly what we need to know, what we need to do, and then you put in place the steps that you need to take to get there. So the way we work is we usually have 2 promotion rounds, I guess. So one at the start of the year, one in the middle of the year, and you essentially start working towards making an application at those times of the year about a year ahead in advance, just to make sure you've got everything in place. The reason I say it's transparent is because in other places that I've worked, there is no structure like that, and getting a promotion is often arbitrary and at the discretion of one person and without any clear objective criteria. So that's why working somewhere like here, and a lot of firms are very similar, having that clear outline of where to go and how you get there, I found really helpful.
And just briefly, you mentioned internal application. So it's an internal application process whereby people just don't come and tap you on the shoulder. You've got to apply for it where you're working.
Yeah, and more often than not, if your partner thinks you're ready, you will get that tap on the shoulder, but then you have to go and prepare. It's actually a written application here. I think it's similar in other places. And you just write down basically how you're meeting the criteria. That gets put to management and HR, and then a decision is made. So, and there's also, if you don't get it, there's feedback. So there's always that sort of focus on development in the background as well. So if you don't get it the first time, you know exactly what you need to do to get it the second time.
Sure. So a tip for young practitioners may be just keep a diary of those points that you may bring up in a future application, so that when you sit down to an application like that in, you're not racking your brain trying to work out what have I done.
Tim, what I would say as well.
Sorry.
What I would say, just one of my tips is that if you get any good feedback, keep it. So it might be that you got an email from a partner saying, well done, Caitlin, did a great job. Keep that email, file it away. And when it comes time to make your application, you've got all the evidence. So that would be my tip.
Great tip. Excellent. And Tim, for you, is progression clear in-house?
Yeah, if I might just provide a tip on a tip. So it's one thing that I always did, particularly through private practice, is so maintain internally that record of accomplishments and the sort of key strategic work that's done and delivered and leads to promotion, but also in parallel to that, maintain a current CV, because then you can follow those things together and keep a consistency and keep an idea of where you're at. In terms of progression in-house, it's somewhat dependent on the scale of the business. So if we were talking legal in Telstra or legal in Westpac, then there is a structure that's more defined like a big law firm. Outside of that, progression is somewhat less clear. The stages are less clear. For me, now that I'm one step down from Group General Counsel, the sort of next role for me is direct work with the CEO at a Group General Counsel level. For others, the senior legal counsel, they might stay in that role for 10 or 20 years in-house and do great work along the way.
Yeah, good. Okay. So, all right. Thank you. I'm going to ask you both now, what do you see as the biggest difference between in-house and private lawyers? Caitlin, I'll start with you and then I'll come back. Tim, you've seen both sides of the fence and your insights are going to be slightly different to Caitlin's. Caitlin.
My insights are probably a bit limited because I have only done the private practice, but I have worked with in-house solicitors on various matters. And based on that experience alone, I would probably, and Tim, feel free to correct me at any point because I've not actually done it. But my experience is that in-house seems to be more focused on or requires a greater degree of management. So it's almost like a project. You're sort of focusing on juggling all these different parts, and we usually come in when there's a particular part that either requires too much time or too many resources, and they need that specialised expertise. So in that sense, we're the wheels and the cog in the wheel that gets some of the work done, but the in-house lawyers that we work with manage us basically, and they manage expectations and what they want, and we're just there sort of doing the work, I guess. Whereas we don't necessarily, we manage our own matters obviously in our own time, but I don't think in the same way that in-house has to manage all the different moving parts. So, but that's my only experience.
Sure. And Tim, for you, what do you see the difference?
I suppose I'm speaking more to, what do people think of lawyers and how do lawyers sort of act and behave. And I tend to think that the systems that you operate within drive the behaviour. Therefore, I think in private practice, lawyers can become or can be more transactional, and that could be attributed to the billables and the need to recover as a sort of defining feature of the relationships that you develop along the way. Whereas in-house lawyers are sort of vested and in the longer term required to build those relationships across and deeply through an organisation, and so might be, I suppose, able to apply more time to build those relationships.
Great. Look, you mentioned billables there again. I'm just moving to a couple of these questions earlier than I planned, but there are a couple of questions. So one of them, Justin says, following up to what Tim said, as General Counsel with a team of lawyers, despite the lack of billable targets, is there still a need to justify resources allocated to that team? And how do you go about that when compared to external spend?
Yeah, that's a fantastic question. And to a degree, the answer will depend on the model that the General Counsel is operating, and that is whether you run a very lean in-house team and outsource most of the work, or whether you run more in-house lawyers and refer less out. That's what we tend to do. So we tend to keep the technically complex, very challenging and potentially extremely costly work in-house. So my challenge, being the sole lawyer without the team, was to justify that resource or capacity allocation. I went about a fairly systematic process using, in the end, software called Zakia, which enables me to track the number of matters, the turnaround timeframe on matters, and even things like the strategic significance of those matters. And so I use that to produce reports at a sort of executive level and say, here is what we've done internally, and this is the cost of the legal function internally, and here is what we send externally, and contrast the value and prove in a quantitative sense the value of in-house counsel. And when I say that, I mean prove that we need one more lawyer, we need two more lawyers, or we need a new senior manager. That kind of discussion is sort of able to be aided by technology these days.
And I imagine the business that you're working for would be very keen to be looking at those sorts of benchmarks all the while to determine whether or not they should be growing the team or contracting the team.
Yeah.
To meet the needs, because it is a balancing act, isn't it? Do you have the expertise in-house, or do you have to go out and buy it? And if you're buying it, and we're going to be paying a lot for it, and if we're paying a lot for that sort of expertise, is that the sort of solicitor we should have on board? So it would be an ongoing question.
Yeah.
Another one, I'll come back to, I'll put this one to Caitlin, but Tim, you'll have a view on this too. This is from Anonymous. When working towards the daily target of, let's say, 6 billable hours, what is the expected threshold number of hours you can spend on a single client per day?
So that's something that's managed at a partner and managerial level. So before you start work on a matter, you obviously enter it into an agreement with your client as to the scope of the work and the money that they're going to spend on it. So essentially the amount of time that you spend on the matter is guided by that agreement, and often your partner and yourself will closely monitor your progress against the estimate that you've provided to your client. And if it gets to a point where, for example, you've said that you can prepare an advice and it might take you 2 or 3 hours to do so, and you provide an estimate to the client on that basis, but you find that the matter turns out to be far more complex than you thought and is actually going to require twice the amount of time, then that's when you revise it, you stop your work, you go back to your client, you let them know what the deal is, they give their approval for you to continue, and you go from there. So it's not a decision as a junior in particular that you get to make. You're always working in close collaboration with your partner to manage the client expectations as well. And it is guided by what the client wants and what the client's prepared to spend. And sometimes it might just be that you've got no choice and you just have to spend the time on it. And it might just get written off at the end of the day. But that's also because you're in communication with your partner, they're aware of it. It's something that can be taken into account if you're worried about your KPIs later on. So it's sort of one of those sort of issues, a bit outside of your control, really. But as long as you're in your communication with your partner, it's fine.
Great. And Tim, just briefly, have you got a response to that? Because I'm going to come to another question for you.
Yeah, I suppose I can just reflect on my sort of last role in private practice as senior associate, where I had 2 associates working for me and then 4 lawyers underneath that. And essentially that's to endorse what Caitlin said, and that is I determined who did what and who was doing what on a daily basis across the different matters that we had. So that might have been divided up by project, by client, or even down to task level.
Sure. And a question for Tim. Are there many opportunities for junior/graduate level lawyers to enter in-house practice? It seems like the majority of these roles come from private practice, whereas a lot of in-house roles seem to be aimed more at senior lawyers with some private practice experience under their belt.
Yeah, that's right. There are opportunities at the junior level. They are very rare. And particularly in Adelaide, but I think generally across the bigger legal functions, there are some opportunities for entering into the legal function as a graduate. I have seen these in other organisations, or people sort of moving in from other roles inside a company as a law graduate. I think generally for in-house, the preference is still that there is a sort of training ground in private practice. And I can be sort of quite specific about sort of why that can be helpful or be perceived as helpful for a company. And that is simply that I've trained 2 graduates in my current role. And what I can't offer those new practitioners is the opinion of a 30-year solicitor, another special counsel, or provide them with a sort of group of colleagues at the very junior level as well. Whereas the bigger firms in particular have the ability to provide a much more sort of diverse range of sort of mentoring and development.
Okay. All right, I'm going to go to a question for Caitlin. If a law firm takes on a matter for a client who has a particular limited budget, i.e. $40,000, and that matter progresses to trial and blows out the side of the client's funds with no further source of funds, will the client simply run out of money or have to withdraw from the matter due to being unable to fund the matter going forward?
We would never get to that position. So you will always, from the outset, try and get an understanding of what your client can afford. And we often provide estimates from the first engagement until trial. And we do let them know how much it will cost. And obviously, trial is just incredibly expensive these days when you take into account counsel fees and stuff. So if we took on a matter, the client came to us with an issue, and we thought it would go to trial, we would tell them how much it would cost. If they only had a budget of $40,000, but trial's going to cost $100,000, we probably it might be that we don't agree, they might not want us to assist them at all, or we might provide them with preliminary assistance. So do we do enough work to get them to mediation to try and stop the matter going to trial at all, and they use their $40,000 in that way. But it would never, and it might be that we only use $20,000 by the time we get to mediation, and then we've got another 20 to play with after that. But it would never be the case that you would just run up fees that your client was not in a position to pay, because that's just not how we work, and it creates issues for your client and it creates issues for your firm, because then you've got issues of debt recovery and no one wants to be in that position. So that's why it's always important to provide that big estimate at the start and then to break it down into stages. And once a stage has been completed, you check back in with your client. How are they going? What do they want to do? How do they want to proceed? And then you go from there. It's incredibly important to check in with your client. I can't stress that enough. So, and to never just go ahead, and you always need instructions from your client. You can never go off and do your own thing because you think it's best. You always come back to your client first and get instructions to proceed. So
it's communication, yes. Isn't it? Yes. Yeah. Another question, which is a really interesting one, are the moot competitions or practice trial runs within private practice corporations a way to build confidence and experience for the associates?
Moot competitions?
Yeah. Are there moot competitions or practice trial runs held within private practice corporations? Now, there are a lot that are held at law schools, etc. Is there anything held in-house that either of you are aware of?
Not at my firm. I'm not aware of any other firms, but I can't speak for them. I'm not sure. And your court experience will come on the job more often than not. So as a junior, you go down, you do directions hearings, you do adjournments, really simple sort of applications. That's
often at short notice.
Experience.
Often at short notice, yes.
Often at short notice, yes. If you're really unlucky. Yeah.
All right. I've got a question here from the Q&A. What technology system is in use for managing billable hours and work assigned to resources? What is your view and experience in offshore modelling in drafting? Okay, 2 questions there.
Okay. Can probably answer the first part. It obviously varies dependent on firms. We use a particular application called Expert Time. So from your solicitor end, it's not very involved. All you have to do, you open the program, you open up a timer, for every matter that we have into the firm, you're assigned a number, and that helps track basically how things are filed and how things are billed. You type in your matter number, you type in your narration of the task that you're doing, and then you click go, you work on your matter. When you finish, you click stop. And then at the end of every day, you submit your time. So just by pressing literally a button that says submit, and you do that again and again. That's our firm. I know that other firms have a very different method of operating. I know some people do it manually and written, and others use very similar programs to ours. But again, we're sort of at one end of the program, and I don't really know how it works once it gets to finance. So
because there must be overriders in case you click start after lunch.
Yeah. There's definitely ways that you can go in and adjust time if you need, or if you, things like that. So it's not, once you hit submit, it's not the end of the world if you've written the wrong thing.
Cool. Tim, what's been your experience with billable hours and technology?
I suppose consistent with what Caitlin said, so different systems at different firms, but all fairly sophisticated time tracking, but generally by matter number, and setting that timer running, and then stopping that timer, and then patching it to catch all of those units. One tip would be to, for any new lawyer in private practice, would try and become an exemplar of time recording.
Do it on the day.
Do it on the day, yeah.
Yeah, do it on the day.
I have seen a telephone-based app that works very well and even links incoming emails and outgoing emails and that sort of thing to
Okay.
the time charging and so on. Okay, this is from Kaylin. Caitlin and Tim. Sounds like Tim started in private firms before going in-house. Clearly, yes. It looks like this is the trend. I snooped on many LinkedIn profiles, and that's a great tip from Caitlin. Do have a look around in LinkedIn profiles. You'll get a bit of an insight into how people have progressed. Would it make any sense to start as a paralegal or graduate lawyer in-house? Would this limit the possibility of being employed by a commercial/private firm in future? And I guess that's that general question of if you go down a particular path, are you closing other doors or are you keeping them open? What do you think there? Tim, I'll go to you first.
Yeah, sorry, I'm not sure.
Yeah. I suppose there's going to be sort of countervailing views on that. My view is very much informed by the sort of idea of a growth mindset, and that is that any training ground will open you up to more opportunities. And an example of a junior lawyer, graduate lawyer that started with me, we went through a full supervision process, and she, from that training ground, went on to start her own firm. So there are sort of as many opportunities as you want to sort of find for yourself. There will also be, in particular markets, in-house, the ability to use the network you would develop in-house to get into bigger firms. And so if I took sort of the niche area of consumer finance law that I operate in, there would be the ability for lawyers that have worked in our team to move in to the equivalent teams in firms like Kingwood Mallison and Ashurst, Clayton Hills.
So it could work both ways.
Yeah, absolutely.
You could go from those sorts of firms, which I understand there was a fair migration from large commercial firms into banks, etc., into consumer finance and so on. But it can go the other way.
Yeah, absolutely. It can go the other way.
Look, that leads me to a question. The challenge, someone has put up the question or a statement, the challenge there though is coming to law later in life. In-house can appear more attractive than the run-of-the-mill clerkship traineeship in larger firms. Is it, look, you recognise that sometimes people who have worked, for example, in finance for many years and then go off and do law, are well suited to working for in-house lawyers in finance. Someone who has had work experience out there, is it an option for them to look to the industry that they come from and look for opportunities within law within that industry?
Yes, absolutely. And absolutely the sort of in-house lawyers will see the benefit of all of that experience. And I suppose very relevant that our current junior lawyer in my team came from a background in banking over about 15 plus years. And so that was a key differentiator for me in making that sort of decision to hire that person because I knew there was this body of experience and knowledge that was directly relevant to the work that we do that would enable us to sort of deliver more quickly the value that the business needs to see from the legal team.
Okay, this is a question that I'm going to throw out to both of you, and this is one that many young law students and graduates will be will be fresh on their mind, right at the forward of their mind. Do you think AI, artificial intelligence, can take over the lawyer role in the future? Which affect the job will it affect the job market for lawyers? What are your views?
Personally, I don't think that AI, again, I don't know a lot about AI and how sophisticated it is. My understanding that at the moment AI is used for fairly, what would you say, like without a better word, simple, almost mathematical legal issues where it's just a matter of input, like it's black and white. You can just input data and it'll spit out a result. But I don't think that you can ever really replace that need for a lawyer-client relationship either, and the need to have someone to manage, because a legal dispute in particular can be very daunting, and not many people understand how the legal system works, and they often rely heavily on their lawyers to hold their hand through that process. So I don't think, yes, AI, it might be the case that it can help with some research, it might be it can spit out an advice, but I still think you always need that relationship. And even when it comes to legal issues more generally, that there's so many grey areas, and I feel like there's often, so you have to think laterally and you have to think of all the possible scenarios and options for your client. And again, I don't know if AI is that sophisticated, but I find that, I would hope that you'd still always need that human sort of element to, I don't know, think about what your client wants as well, and
sure.
Be more commercial about it. Yeah.
And Tim, your thoughts?
There's a great deal written about this. It's all very interesting. And the College of Law has some great modules in the master's courses on technology in the law. I am, I suppose, a proponent of enabling AI in sort of legal service delivery. I don't think that it directly threatens the jobs of lawyers, but I do think that it will fundamentally change the work that lawyers do in the future. And it will loop all the way around to what Caitlin's just been describing. But there is a place for AI. I have sort of direct experience using a tool that Clayton Utz has called Relativity, which is a fairly sophisticated AI machine learning platform. We use that to review more than 1 million documents. That meant that rather than having to have individual lawyers review 1 million documents, we were able to refine that list down to 28,000 and ultimately down to 8,000 that required legal review. And that saved us in just one matter hundreds of thousands of dollars.
Yeah.
More broadly, I think AI will come in to enable document automation, but what we need to do is adapt and be able to become the interface between the outputs of technology and the humans who are instructing, because it's going to be a long time before the AI will be able to sense things like, a reasonable example would be taking instructions on a will and asking wife whether they have any other children, and noticing that one of them was very uncomfortable during that process. Well, the computer's not going to pick that up for a long time, but a good wills and estates lawyer will.
Absolutely, yeah, that's a very interesting observation. Okay, when applying for positions in private corporations as a graduate, how much experience is needed in the legal field, with the exception of having done PLT in a summer program internship from the penultimate year? So, yeah, that's...
So how much experience?
Yeah.
It also depends.
Go on.
Yeah, I was going to say, it probably depends. Again, you're all PLT students, so you're probably going for clerkship and grad roles. So it's always good to have some sort of work experience. Obviously, when you're coming into a clerkship or a grad program, we understand that this is probably the first time you've even come near a private firm. But what I would say is, prior to making any sort of application, it's obviously try and get as much work experience as you can, volunteer, get your name out there. Be prepared to work for free, obviously. I'm not encouraging like slave labour or anything like that, but it does take a bit of you have to use your own initiative, approach people. And it might be you only have 2 weeks of experience or 1 week, and that's fine, because we do look, when you make applications to these firms, we look at factors outside of just your grades and how much experience you've got. And often by the time, say you make an application, you've got great grades, you might have done a bit of work experience here and there. Once you're in and you've got your interview, it's all about you, and it's all about whether you're fit, and your personality and how you come across. So back to your original question, you don't need a whole lot, particularly coming to clerkship and grad, but I would highly recommend that you do as much as you can, so that when you do come, you're not completely shocked or taken aback by the type of work that you need to do. But obviously that applies. It's different if, for example, you're a 1 or 2 year solicitor out. You're going to have a bit more experience to jump into those roles in other firms. So.
Cool. And Tim, do you have an insight into that one?
Yeah, I completely agree with Caitlin to, I suppose, take every opportunity to get as much experience as possible, but don't be dissuaded from looking for opportunities due to a experience.
Yeah.
Sure. Look, I'm going to ask for your tips and traps shortly, but just specifically at the moment, focus on, it's a similar question, but just slightly different. What are the non-legal skills that you would suggest to young practitioners? What do they need to be developing? What should they be bringing with them? What should they be looking at? Caitlin, do you want to go first with that one?
Yeah, sure. They're all very general, probably common sense, but obviously time management is a huge one. As a young solicitor, you're going to have, it's not like you work on one matter at a time. You're going to have multiple matters that you're going to have to juggle, multiple tasks, often with competing deadlines. So you need to have the ability to map out your week, map out your day, and have an understanding of your capacity to actually get these things done. Another, and linked to that, is communication. Cannot stress, again, I've talked about this a lot, but communication with your partner about your ability to meet those deadlines. So don't feel like the pressure to just try and get it done and hope that you do. You need to be honest, you need to be upfront, you need to tell them where you're at and what you expect and what you can actually manage, because it might be that they just delegate the work to someone else, and it's better that way than for you not having met your deadline and looking silly because of it. And then also that extends to your communication. You're going to be obviously interacting with a lot of different stakeholders in private practice. You've got other lawyers, you've got your clients, your colleagues, and then court staff in particular. Be nice to court staff. Yes. So it's just learning how to work with people, to compromise, to negotiate, and to not take things personally, really. That's probably one of the biggest things I learned pretty quickly. It's not about you. So just, they're my two big ones, time management and communication.
Thanks for that. Tim, what about you? Tim, can I ask, do you touch type?
Yes. Yeah, I can type sort of without looking at the keyboard. So absolutely.
And like, for example, I can't. And it's something I said to my son when he went into accounting, you should do it. And he said, yeah, sure, Dad. He never did. He's sorry he didn't, because it's the sort of thing that can save you hours. But carry on, Tim.
Yeah, absolutely. So 2 tips on skills. I think fundamentally important is interpersonal skills. And some of what you were talking about, Caitlin, goes to interpersonal skills. Yeah, that's the ability to relate to your partner in the firm, to your clients as well, and develop the ability to interact with all sorts of different people in non-judgmental ways. Prior to the law, I worked in hospitality. I think that was a great sort of training ground for developing the ability to deal with all different types of people in different types of scenarios. So I'd recommend exposing yourself to a fairly broad range of people and modes of communication on the way through university. Technology. My expectation would be of sort of Gen Y or Gen Z coming through is that they are absolutely fluent with all the current technology and use it. I try to do the same to keep up with it. But I'm operating in a company where our products are sort of targeted at millennials and Z.
Sure. And I must say to young practitioners too, that don't overlook those jobs that you've had before and after school, that customer contact that you've had all the way through. These are the sorts of things that you can emphasise when you come to put your applications in and sit down opposite people. Even though they're not law related, they're people related, and a lot about this industry is people related, and so don't underestimate it. Look, Lee has put in a query here. In today's market, many graduates are faced to accept a role that is quasi-law, but not actual legal work, e.g. contract specialists, reader and other auditing, compliance work. What would you advise, what would your advice be when you need to still satisfy 2 years of conditional practicing certificate? I mean, the 2 years practicing certificate, that's clear. You've got to be supervised by an admitted practitioner. So if the person who is supervising you is not an admitted practitioner, you won't get a practicing certificate in the first place, and you won't start your restricted practicing certificate period. So in that case, it's something you need to check with your local admitting authority, but I think you'll find that if your supervisor is a non-lawyer, then you're not going to be dealing with that anyway. But do either of you have anything you could add to that?
Sorry, Caitlin.
Oh, no, I agree with Gray. I was going to say, I think it depends on the requirements of your law society. So, yeah.
I have a sort of two-stream response for that. Firstly, sort of generally, I'd say, try and find a role where you can be supervised by a practitioner with a practicing certificate that will enable you to ultimately get towards what might be a Category A or an unrestricted practicing certificate. But just now, given that we're in an economic crisis, I would advise any sort of new lawyer looking to get into the market to just find a role, find an opportunity, and get through this crisis to enable you to get to those opportunities within the profession where you want to be in the longer run, because the crisis will pass.
Absolutely. And on top of that, I think that we shouldn't overlook the fact that the jobs that we don't know are there yet, the ones that are emerging, they may well emerge, and you may never need a practicing certificate for that. You may not even need to be admitted, but go on, get yourself admitted. But if you don't need to actually have a practicing certificate, but you still find a fulfilling role on the edges of law, and that may just be where you really want to be. So it's something that you should be eyes wide open, looking out for those opportunities. Look, the time has come to 6 o'clock, and lots of great questions have come up online. We've addressed most of them. I want to say thank you both very much, Caitlin and Tim, for your participation, and thank you for everyone else who participated and the questions that came up online. They're terrific questions. And look, I want to wish you all the best, everyone, and take the opportunity to attend as many of the events as you can this week, or look at them online after the event. And just like to say thank you and good night, everyone.
Yeah, thank you. Good luck.
Thanks. Bye.
Yeah. Bye.